morning or good afternoon, viewers, depending where you are. This is the newest episode of our podcast, the Slarskey Brief. In this podcast, we discuss hot topics in risk-based litigation and litigation funding and basically everything adjacent. Today's episode is international and cross-border asset enforcement. We're joined today with two guests from around the world, Rosie Wild of CYK out of London and Katie Pearson of Claritas in the Cayman. I'm Evan Freed. I'm a partner at Slarskey LLC. We focus on the range of commercial litigation. Much of my work personally involves investment frauds, judgment enforcement, and cross-jurisdictional work. Our firm frequently works on contingency and hybrid basis. Our guests today, Katie and Rosie, do you mind just introducing yourselves?
Sure. I'm Katie Pearson. I'm the co-founder of Claritas. We're a boutique law firm in the Cayman Islands, specializing in litigation, insolvency, and regulatory law. I'm an English solicitor by background. I trained at the Magic Circle firm Freshfields, and then I worked for a boutique fraud litigation firm called Peters and Peters before moving to Cayman in 2009. I quickly realized that the longer you stay in Cayman, the harder it is to leave. And I've just passed my 16-year anniversary of living and practicing in Cayman. So when I first moved to Cayman, I practiced for Appleby and then Harney's, which are both global offshore law firms. I was in the litigation department of each of those. And then in 2022, I left to co-found Claritas, really to offer clients an alternative to the global offshore law firms for their litigation and insolvency matters. So my practice covers the whole range of litigation and insolvency, but I have a particular focus on fraud-related matters. So I often get freezing orders or disclosure orders for assistance to foreign proceedings, and also provide assistance to foreign bankruptcy trustees who need things from Cayman.
Awesome. Rosie?
Hi there, my name is Rosie Wild. I'm a partner at CYK, which is Cook, Young and Keidan in London. We're a disputes boutique. We focus on all types of commercial litigation and arbitration. My particular focus is matters of civil fraud, much like Katie and Evan. And around maybe 5 years ago now, I was involved in a massive freezing injunction against about 31 defendants, where we obtained what we understand to be one of the first freezing injunctions against persons unknown, at least in this jurisdiction, which was very interesting. And maybe I can talk about that a little later. But we do a lot of civil fraud work at CYK, but all types of litigation and arbitration. And we're a small team based in London.
Awesome. Well, look, the three of us have a lot in common. We all focus on investment frauds and asset enforcement. We're all at boutiques, not big firms. And we all focus to some extent, or at least are interested in risk-based approaches to litigation, whether it be contingency or hybrid. We're also all spread around the world. So I guess that should be the focus of today, both what draws us together and sets each of us apart. So let's start with the type of work that each of us are doing. Each of us have quite a bit of judgment enforcement and asset experience. We've each shared plenty of war stories with one another. Can each of you just provide an example of something you've worked on in the past 5-10 years that's kind of symbolic of the type of work that you do in this area?
Sure. Well, maybe I can talk about the case I mentioned a second ago, which was a worldwide asset enforcement case. It started out with about $8 million. So not massive, but not tiny either. The equivalent of $8 million being stolen from a bank account in London. We knew the first layer of where the money had gone because we could see from our clients' bank statements, but very quickly we had to work to obtain the freezing of those assets and then obtain multiple disclosure orders so that we could see the full pattern of where the money had spread. That's fairly typical of the type of work that we do. So using a combination of freezing injunctions and disclosure orders and other relief to try to trace stolen funds and try and seize the money as quickly as possible. That case was very interesting. It went on for a number of years. In fact, there's still enforcement attempts going on in different countries now. It spanned around 15 jurisdictions in the end. So as I mentioned, CYK is only based in London, but we have excellent connections with other firms overseas, which is part of how this podcast has come about, with other great law firms that we work with, and which allows us to be really flexible, which is great. And in terms of enforcement of that judgment, because the proceedings were issued before Brexit, or before the end of the Brexit transition period, which was December 2020, the end of the transition period, and we'd issued in advance of that. It meant that we could happily take advantage of the Brussels one recast regulation in order to enforce the judgment across the jurisdictions, obviously European jurisdictions where the money went, which was a bit easier than the process is now, certainly, and led to actually very quick recognition and enforcement of the judgment overseas. Again, working with lawyers on the ground there, but quite simply filling in what used to be known as an Article 53 certificate and putting that on top of the judgment made it very simple. Now, by contrast, when we enforce judgments overseas, it can be a tiny bit more complicated. We've got the Hague Convention, but obviously that's not going to quite respond in all cases of fraud because we don't have that exclusive jurisdiction in a clause in a contract to help us out. So it can be a little more convoluted, but still very, very manageable. But that's probably a good example of the kind of breadth of experience having civil fraud matters. And it was also the first case, as I mentioned, against persons unknown, specifically in a freezing injunction context. It's been used elsewhere in other contexts before. I can speak a bit more about that later.
So Rosie talked about a freezing injunction, and I've actually had a couple of freezing injunction cases this year. In both cases, we were seeking freezing injunctions from the Cayman court in support of proceedings taking place overseas. In the first matter, we were acting for Novo Nordisk, which is a global pharmaceutical manufacturer. They make Ozempic. And they had bought a drug from another drug company, which subsequently transpired it didn't work. And the sale and purchase agreement had a New York arbitration clause. So the underlying dispute is now being arbitrated in New York, but the defendant company is a Singapore company with a Cayman holding company. And from the Singapore company's accounts, they could see that of the $700 million purchase price, a very large proportion of it was transferred up to the Cayman holding company. So before the arbitration was commenced, they got freezing injunctions from the Singapore court against the defendant company and the founder, who's also based in Singapore, and from the Cayman court against the Cayman holding company. So that's a matter where we were coordinating, obviously, with the lawyers in Singapore and New York to get this relief, and very, closely coordinated in terms of timing, because the Cayman application had to go after the Singapore application, but it had to go immediately after the Singapore application so that the defendants didn't get tipped off by being served with the Singapore order before we had the Cayman order. We found the Cayman court to be extremely helpful and accommodating. So the nature of Cayman as a jurisdiction is that we have a lot of companies, and the companies are typically set up by people who are not in Cayman. So it's very normal that the matters that the Cayman court is hearing have cross-border elements, and that there are proceedings going on in other jurisdictions. So in that case, we were able to write to the Cayman court, I think on the Wednesday of the week before, to say, we think we're going to need a hearing next Monday for this reason, because this is what's happening in the other jurisdictions. And the court was really accommodating. I think within about an hour, we had a response from them saying, this is your judge and you're listed at 2:00 on Monday. That's, I think, a very good example of what the Cayman court can do to support litigation and asset recovery efforts that are going on across the globe.
Each of us is in a different jurisdiction, UK, Cayman, New York, and each jurisdiction has different contours as to the remedies available and also what's not available. Why don't each of us walk through a unique feature of the judgment enforcement and asset recovery landscape in each of our jurisdictions? I guess I'll start. In New York, we recently worked on a matter where a client, which was an investor in a fund, had been the victim of a Ponzi scheme and misappropriation back in the financial crisis in 2010 or so. This judgment accrued, and the previous counsel kind of beat their head against the wall, frustrated that not only was the judgment debtor hiding assets, but also there were what appeared to be pretty bad jurisdictional issues where the debtor's assets or the assets believed to be controlled by the debtor were outside of New York. When we came in, we did a lot of work on this, and New York has very good Court of Appeals authority, the Kohler case, that deals with precisely this issue. And basically, the gist is, even if there's no in rem jurisdiction, even if the assets are outside of the state of New York, there's quite a bit of power in the fact that there's personal jurisdiction over the judgment debtor himself. In this case, the judgment debtor had run his business in New York City while he was perpetrating this Ponzi scheme. And even if he moved himself out later, it was a New York judgment and there was still jurisdiction over this person. So the New York court in our case exercised its discretion to pierce LLCs, to order certain hard assets like expensive cars and whatnot brought into New York State, which quickly drove a resolution. Katie, why don't you tell us what's unique about the Caymans?
So Cayman law is based on English common law. So we have broadly the same remedies available that the English courts have. That includes freezing injunctions, which we've already talked about. It includes discovery orders as well. We can get discovery from third parties under the Norwich Pharmacal jurisdiction if we can show that there's been some wrongdoing and they've been mixed up in it. We can also get evidence for use in foreign proceedings pursuant to the Hague Evidence Convention. But I think, in terms of what makes Cayman special, it's probably the international focus of the courts and the judges and the legal profession here. The fact that pretty much every case that we see has overseas elements to it, and often the substantive litigation is actually happening overseas, and what we're getting in Cayman is a freezing order in support of somebody else's proceedings or a discovery order in support of somebody else's proceedings. So I think the Cayman courts are very good at navigating the issues that throws up, and they're very willing to help the overseas courts, but they're also quite sensitive not to overstep the mark and go further than they should. So that's what I would say is the kind of unique feature that we have.
Awesome. How about you, Rosie?
Well, I think that two of our kind of most powerful kind of unique features have been touched upon already, given the overlap between English law and Cayman law in terms of freezing injunctions and Norwich Pharmacal applications. So maybe I could just highlight a couple of smaller points and I can elaborate on later, which is the English court seems to have a similar approach to the Cayman court in terms of it's very willing to respond in cases of fraud. So if the English court can see that a fraud has occurred, you're basically pushing at an open door. And I can come back to that a little later, because that's in some recent cases, it's been causing a few issues, I would say. And indeed, what used to be kind of our freezing injunction called a nuclear remedy, and it was granted only in the most serious of cases for the most serious frauds and so on. It's actually being granted more and more often, because obviously we're seeing a rise in civil fraud cases anyway. Lots of cases that come across my desk now have a fraud angle, whereas maybe before you wouldn't have necessarily seen it as a fraud case. I think that's leading to the rise in freezing injunctions, which is leading to the English court granting more of them. In turn, that's creating some issues, I think, sometimes, because it's being used as potentially a weapon against the other side, because obviously it's a very dramatic remedy. We talk about it freely here because it's our day-to-day business, but what you're actually doing is you've got an in personam remedy, as you mentioned, Evan, against somebody else, and you're freezing their assets, of course. I mean, the clue's in the name, and that's obviously a very heavy form of relief. We find the English court grants them very often. They don't always survive the return date, especially if you've got a respondent that comes on the record and is up for the fight, but they are certainly being granted at a certain rate and pace. Then what I would say is that when people are then in breach of the asset disclosure in the freezing orders, which often happens, or the defendant just can't quite get their marbles together quick enough in order to respond to the freezing injunction. If the respondent doesn't be seen to be complying as soon as possible, sometimes then the applicant entity or person can take advantage and threaten contempt of court proceedings, which is obviously another weapon that can be used in litigation sometimes. And often it's used in the right ways, that's fine, but we're seeing these things being coupled together to basically, I wouldn't say necessarily stifle a respondent, but it can be very difficult if you find yourself in the position of acting for a respondent where the applicant is kind of taking advantage of these things. And even if the contempt application doesn't necessarily have good grounds or good merit, I think the fact that there's a contempt application out there can be difficult. So I think respondents need to be really careful when freezing injunctions are made or when they're threatened or so on. They're obviously not threatened very much because the whole point is that they're made ex parte without notice to the respondent. But that's something I would say in terms of what I'm seeing in the landscape of English litigation at the moment, and maybe more thought going into the granting of freezing injunctions in order to maybe curtail the wave, let's say. In terms of Norwich Pharmacal applications, we're all go there. The English court is very keen to grant them. We do that a lot, and we see that a lot. It's a really powerful remedy, and it can really help at the first stage to try to gain information, of course, which is what they're for. There was a bit of a lacuna in the law a couple of years ago that got fixed by way of an amendment to our civil procedure rules, making sure that there's now a service out gateway, meaning that we can serve our Norwich Pharmacals outside of the jurisdiction on foreign parties. So the law was a little bit unclear before that. There was still a way through. I'd still done it many times, but now it's been cleared up. So I think that's, again, the English court just being willing to make sure that things can run smoothly and that applicants or the victims of fraud can have a kind of a smooth ride to recovery, let's say.
So that's an interesting, actually, difference between English and Cayman that you've just mentioned there, Rosie. So the fact that in England you can get a Norwich Pharmacal against an overseas party and you can get a leave to serve that overseas. So in Cayman, we can get Norwich Pharmacal orders against Cayman entities, and we often do get them against the registered offices of Cayman companies or other entities that are resident here. But that's somewhere where the Cayman court would kind of know its place, so it wouldn't want to make a Norwich Pharmacal order against a bank or somebody out of jurisdiction and give leave to serve out. So the Cayman court will certainly assist, but it's very mindful of its jurisdiction and the limits of that jurisdiction.
No, completely. And I think that the English courts are mindful of it too. And in fact, some disclosure orders that have been made have then been kind of overturned. There was a case, I think, Senna and Persons Unknown a couple of years ago, which was to do with disclosure orders against banks in Australia. And essentially the Australian banks didn't comply. And the English court said, well, number one, that's because they basically cited their own confidentiality obligations to their customers, which is completely right. And so basically you really should put forward evidence to the English court when you're seeking Norwich Pharmacal against an overseas party. Really, what I don't understand is how many lawyers make Norwich Pharmacals against foreign entities without actually first going to the local jurisdiction and asking what the position is there. I think I've written a few articles on this subject before because it just fascinates me, because that would be the first thing I would do. Is if I needed disclosure from a bank in Australia, I would call up kind of a firm that I trusted in Australia, check the position there and check whether it's worth going via the local courts there first, rather than trying to get a Norwich Pharmacal in my own jurisdiction, then have to go through what could be a difficult enforcement procedure in a different country. Also, as you've said, Katie, with your Cayman courts, the English court will balance it up. And if there's an appropriate remedy available on the ground in the foreign jurisdiction, the court might refuse the remedy in England and not give it to you because it said, look, you could have done this locally. I'm not going to, use my long arm jurisdiction against an entity that's overseas when there's local procedures that could be followed. And also when I'm not aware, English court, of the obligations that local bank is under in its own territory. And that's a reason why, if you are going to seek a Norwich Pharmacal against a foreign entity, you should always have, if you want your application to be successful, even if not productive later on, you should include a provision in it that says, to the extent that compliance with this order would put the respondent in breach of its local law obligations, it does not have to comply with the order, because that has to be right. You can't obviously force a breach force a local breach by way of forcing compliance. So yeah, it's very interesting. But my advice there is always go to a lawyer in the country first before you start moving in that direction. And then you're way more likely to get your order in England as well. But at the end of the day, sorry, passionate subject here. Once you have an English Norwich Pharmacal order against, say, multiple banks in different jurisdictions, people think that's the end of the matter, but it absolutely isn't, because then you have to go and enforce that local order in those jurisdictions. Of course, sometimes you get lucky and your bank in the foreign jurisdiction maybe doesn't know what it's doing and it'll give you the documents. I've had that before. It's absolutely brilliant if that's the case, but that's obviously few and far between. You just need to be mindful of that.
Yeah, I mean, we have the same thing with freezing orders, Cayman freezing orders. The Cayman court would grant a worldwide freezing order against a Cayman company or a Cayman individual. But then, given the nature of Cayman as a kind of global jurisdiction, it's highly unlikely that that person or that company's assets would then in turn be in Cayman. But we would typically always send a copy of the order to the bank in Canada, the US, or whatever country they might happen to be in. And some of them will voluntarily comply with it because they don't want to get sued for moving the funds when they were on the notice of the claim. Often than not, they will say, well, that's very interesting, but we're not bound by it. Come and seek an order in whatever jurisdiction we're in. But sometimes you do get lucky and they will abide by it.
Yeah, exactly the same. Just putting banks on notice of the freezer, basically. I do often see banks sort of, they write back to you, but there's a nudge wink in it where they've probably frozen the funds anyway because they don't want to be. And also it's worth mentioning their own local obligations and a nod to them, because I'm sure they all have their local anti-money laundering regulations, whatever it might be, to take action to prevent a known case of fraud. So yeah, you never know what you might achieve even just by the initial correspondence before you start to enforce.
Yeah.
Look, each of us, we do both plaintiff and defense work, but one thing that I think draws all of us together is we've done our fair share of creditor or claimant work. And in that vein, each of us has at least explored arrangements where the lawyers share some type of a risk with the client, whether it be through the use of litigation finance or through hybrid or contingency work. What is each of your experience with these types of models, and what are some of the contours that viewers should be aware of in the jurisdictions where you guys practice?
We can be pretty flexible. In England, our law is open to many different types of fee arrangements, but practically speaking, on a day-to-day basis, there's damage-based agreements, which is where you agree to take a share of the profits in the event that your client succeeds at trial or otherwise, whatever the definition of success is that you agree with your client. My own personal view at the moment is that those agreements are very risky to enter into because the DBA regulations, it's well known in England amongst practitioners, and I'm sure Katie will endorse to the extent possible, that the DBA regulations are very difficult to understand, let's say, to be polite, and no amount of reading them makes them any clearer, and no amount of debating them with my colleagues about what the perfect DBA would look like has got me any more confident about entering into one with a client. Now, I think with the right client, you might feel comfortable taking a risk, let's say, on the lack of enforceability of the DBA. But obviously, if you're going to have hundreds of thousands of pounds on the line, or even more, as we know, legal costs can really escalate sometimes in long-running litigations or arbitrations, as the case may be. It might not be that you want to put that amount of money at risk. And quite frankly, I think if you've got a DBA, it could be at risk because it's very difficult to make sure you're complying with the regulations, and anything that doesn't comply would be held, your agreement would be held to be void, and you wouldn't be able to enforce it against your client. And if that's worth £1 million, then it's obviously something to litigate over, and you don't want to be the law firm that's testing this all out for everybody. And if anybody is listening to this and has a DBA template that they think works, I'd be very interested to see it or debate with them about it. Now, agreements that we do often enter into is a discounted conditional fee agreement or arrangement, where for the right type of case, we would happily take a cut in our headline hourly rates, and then there'd be a commensurate uplift in the event of success. And sometimes that really does help clients pursue litigation with a bit more confidence, really, because they know that the solicitors, they've got some skin in the game as well. And also, it's only for the right cases that we think about doing those, because we obviously have to believe that there's a really good chance that we'd recover the uplift at the end of the day. So they are very popular, and there's something that we do on many cases. They can sometimes cause some issues, but I think sometimes that just happens anyway in the course of litigation. But quite recently, we entered into a non-contentious business agreement with a client, which it was quite interesting. And that this is the first time that I've done it, but I think so far so good. I'll let you know if it all goes wrong. But what we've done is we've agreed to act pre-action, so strictly without proceedings being commenced, hence the non-contentious business agreement. And the idea is that if the case settles, or if success is achieved pre-action, whatever success is defined as the assessment of the case with something being paid to our client, so a win on some level, but it's not without issuing proceedings, we're entitled to a share of what's recovered or what's achieved. And that is permissible because it does fall within the scope of the DBA regulations, and so you can be confident that whatever agreement you enter into, as long as it's been well reviewed and well drafted, then it will be enforceable against the client. What I would say though is that if then proceedings are issued, you need to have thought really carefully about what's going to happen to that agreement, because as soon as proceedings are issued, it's very likely that that agreement falls away. But obviously you will have incurred whip of, let's say, £50,000, and it's what happens to that whip then upon the issuing of proceedings, because it can't exist as a DBA because it wouldn't be enforceable, because the DBA regulations apply to contested work. So you just need to be careful about and think in advance about what's going to happen at that point in time.
Well, that's really interesting, Rosie. I was going to say that Cayman's a bit behind the UK, but actually I think we might be in a better position than you, because we don't have your DBA regulations. But what we do have is our Private Funding of Legal Services Act, which came into force in 2021. And that was the first time that we had legislation permitting both conditional fees, so hourly rates plus an uplift in the case of success, and contingent fees being a DBA kind of arrangement, and also third-party litigation funding. So prior to that act coming into force, we did have some third-party litigation funding, but the funding agreement needed court approval in every individual case, so it was quite cumbersome. Occasionally, contingent fee arrangements, so the hourly rate plus uplift arrangement, had been allowed, but again with court approval in every case, and that typically would be used in either personal injury cases where the plaintiff wouldn't have been able to bring the claim, or acting for insolvency practitioners where the estate was unfunded and again wouldn't be able to bring the claim. And those arrangements would require court approval in every case, so pretty cumbersome, not that easy to do. But now, since we've got that legislation, you can enter into those arrangements without having to get court approval in every case. And our regulations are very short, so I don't think we have the same concerns that you have in England about falling foul of them and ending up with a contingency fee arrangement that's not enforceable. Although you do have, I think, different concerns in that, as I already said, the majority of our clients are not in Cayman, so you'd have a Cayman law governed contingency fee arrangement with a client who could be anywhere in the world. So I still think it's something that you want to enter into with a client that you trust, and that that you're not going to fall out many years down the line when the litigation ends up being successful. But anyway, as I said, this only came into force in 2021, so it's all quite new to Cayman. I don't think these sorts of arrangements are yet widely used in commercial matters, but it's certainly something that we've spent quite a lot of time looking at as a firm, and it's certainly something that we as a firm have an appetite to do, because I think there's a lot of meritorious claims that are getting left on the table in Cayman because everyone's billing on hourly rates and the hourly rates are very high. There's definitely scope for it. It's definitely more difficult for us to do it in Cayman, and for you as well, Rosie, in England, than it is in the US, because we're an adverse costs jurisdiction. So if you're acting for a plaintiff who's entering into those sorts of arrangements, you're going to need to get, after the event, insurance, and that's a big cost, either a big upfront cost, or if you do it on a fully deferred premium basis, then they're going to want a big slice of the upside. And you still need to record your time, because if you're successful, your clients want to recover your costs from the other side, but we're only allowed to do that on the basis of hourly rates, not on the basis of contingent fees. I always think it must be very liberating to be a US lawyer on a contingent fee and not have to record your time. But unfortunately, that's not an option for us.
Yeah, so needless to say, the US is the Wild West as it pertains to risk sharing arrangements, whether it be contingency, hybrid, risk sharing with litigation finance. And unlike in your jurisdictions, that liberal policy doesn't exactly stem from legislation. In fact, it's the lack of legislation that in many ways has freed up a lot of roadblocks. It's an interesting point about keeping time. The answer is, I think it depends. In personal injury, I don't know if any personal injury lawyer has ever kept time. However, folks that do work in insolvency, or that they do work in patent litigation or asset enforcement, what we generally observe is the associates and the partners keep their hours, generally speaking, both for internal purposes and for purposes of a fee application. And, there's oodles and oodles of authority out there as to how lawyers are supposed to keep their hours, where are haircuts or across the board reductions appropriate, where they don't keep hours, or they have so-called reconstructed hours. And sometimes it manifests in a fee dispute, or sometimes it's a fee application in one of the exceptions to the American rule where there is a fee shifting regime, but it certainly is out there. I guess litigation finance would be another area where record keeping is important if you're submitting your hours to a funder. Let's shift bases for 1 minute. Each of us have big firm backgrounds in some form or fashion, but we've chosen to chart a slightly different path and work in boutiques. Talk to us about what precipitated your move to a boutique, and how do you think that's worked out or not worked out in terms of asset enforcement and your positioning in the market?
So I decided to move to a boutique basically straight after my training contract. I was doing predominantly arbitration when I was at my previous firm, and I wanted to do arbitration and litigation. I originally kind of fell into arbitration because I love the idea of doing advocacy, but then realized that I wanted the kind of pomp and tradition and everything of litigation. And so I wasn't ready to give up the idea of doing court related litigation. So I moved to CYK now almost 13 years ago to see what life was like. And at the time when I moved, I wanted something completely different to my big firm. I didn't want to go to a smaller version of a big firm. I mean, I know that they're great and they have their own pros and cons, but I wanted a fresh slate, something completely new, to see if I liked it or not, because I loved the big firm that I was at before. So if I was going to leave, it had to be for something that kind of made sense for me. And so I took a jump, joined CYK 13 years ago. It was quite a different firm then. It's still full of great minds and still pretty small, but it was just only about 4 years old at the time, and now it's 16 years old, so it's quite different, which is great. We've really kind of professionalized and we're a lot sleeker than we were, and that has pros and cons too. But in terms of my development over the years, I think it's been great for me personally. It meant that when I was a junior lawyer, I was much more involved on the ground on cases. There was much less of a chance that I'd be involved on one case for maybe multiple years, and God forbid be stuck on a disclosure exercise for 6 months just reviewing documents. Of course, that's part of your life as a junior associate anywhere, but at smaller firms, things are a bit more dynamic and you have more opportunities, let's say. And if you're performing well, then before you know it, you can be drafting the witness statements, and that's great. Certainly a lot of fun. And yeah, from an asset tracing and enforcement work perspective, I think it's been very good for my development. Yeah. How about you, Katie? What do you think?
So I had a similar experience to you, I think, in terms of training at a global firm. And then I moved to Peters and Peters in London when I was newly qualified. And I fully agree that in a small firm as a junior lawyer, if you prove that you can be trusted, you're suddenly, dealing with clients and drafting witness statements and all sorts of things that in a bigger firm you wouldn't have the opportunity to do until much later in your career. So I learned so much from doing that. And then I moved to Cayman. And when I moved here in 2009, there certainly weren't any litigation boutiques. It was either the global offshore firms, which are predominantly corporate and hedge funds focused, with litigation as well, but to a greater or lesser extent, depending on the firm. And they tend to be part of an international network covering all of the offshore jurisdictions. And I was very happy at both of the firms that I worked at here, but I guess I always kind of missed the boutique small firm environment. And I got to the stage where I felt like I could do my job better without the apparatus that comes with being in a big firm. So partly the processes and the bureaucracy and the time it takes to make a decision and do things, partly the conflicts of interest, which is obviously very important as a litigator to be able to act against pretty much whoever you want to act against. And I was attracted by the challenge of building something new and building a law firm from the ground up. So just over 3 years ago now, I took the leap and co-founded Claritas.
Awesome. Well, in New York, we feel the immense pressure of big corporate departments at big law firms where the rates are going truly through the roof because it's simply a rounding error on a very large multi-billion-dollar transaction. A colleague of mine once told me that, but for us, building a boutique has been so much about taking risk, about finding those nugget opportunities, about working collaboratively with others around the world in really creative and different situations that I think the big firms or even the mid-sized firms are not really equipped to do. Katie, that's an interesting point you made. I mean, even some of these boutiques have multiple offices where they cater to various jurisdictions. We're truly a New York boutique. We have our cases in Alaska and around the US, but our preference generally is to work with other firms, not to kind of cannibalize other work, because each jurisdiction truly has their specialty. And it generally helps to have boots on the ground with somebody who really understands that place. And that's something you just can't do at a bigger firm because there's such pressure to keep all the work in-house.
Massively. I think it just enables you to think more creatively, and you're just more flexible because you don't have to run past X other partners, and you make your own decisions, and you're building your own network and your own relationships. And when you're at a boutique firm, you don't have like a corporate department to rely on for referrals and things. You're constantly trying to build your relationships and encourage them and so on and develop them. And an example is a potential client called me this morning, and it's a judgment enforcement, a US judgment that they want to enforce overseas. They want English lawyers to coordinate it. And I'm very happy to do that, but they don't really have much money. So we were talking about flexible fee arrangements, and I mean really not much money at all. And so I was like, this is great, but why would you pay an English law firm to kind of coordinate this for you? What you need to do is try and find a quick asset source that you can tap in to get some funds. Then you can think about maybe instructing me. So I just gave some high level advice and pointed this lady in the direction of an Antiguan civil fraud lawyer who can potentially do a disclosure order on the ground against an Antiguan bank. And that's the kind of flexibility that I can try to get that contact for her, feed it back. She can then make the relevant call, speak to that person directly to see if there's a quick way to understand whether the funds are still there. If they are, happy days, and we can think about getting involved. But genuinely, for the amount of money that she was talking was on the table in terms of being able to run this case before any assets are found, you're just very happy to be give upfront clear advice and to try to connect people with the people that they really should be speaking to at the beginning that might not be you.
Sure. At the bigger firms, there's a tendency to have a feeding frenzy on anything that comes in the door, but to be nimble and to work with other people and to really get stuff done is pretty powerful at the boutiques. Well, look, we're just about wrapping up time. Why don't each of you just give a prediction for your field or your work or your jurisdiction in the coming years and what you're excited to see ahead?
So Cayman has changed so much in the 16 years that I've been here. So I got here in 2009, and at that time there were, as I said, no litigation boutiques, but actually not even that many firms that really had any size of litigation department at all. Quite a few of the firms that we now think of as the bigger established players in the market simply weren't in Cayman at all. Others were here, but as kind of corporate funds firms, and were just building up their litigation department. The 2008 financial crisis was massive for Cayman in terms of hedge funds blowing up, needing to be wound up here. A lot of Madoff feeder funds were Cayman based, and other big frauds like the SARD litigation, which had a 1-year trial here between 2016 and 2017. So all of that stuff that kind of came in that post-financial crisis period really, I think, got the jurisdiction on its feet. The profession grew massively, both in terms of the law firms and the insolvency practitioner firms. 2009, actually, coincidentally, the year that I got here was also the year that the court set up its financial services division. So that's its kind of dedicated commercial division. So to watch that development and be a part of that development over the past 16 years has been really fascinating. We now have some very big cases being tried in Cayman, which I think in the past, wouldn't have been tried here, would have been tried somewhere else had they been tried at all. But the Cayman court has proved itself well able to cope with really large scale, high value litigation. And I can only see that continuing. So yeah, it's going to be exciting to see how that development carries on.
Well, for me, maybe I can just close off by saying something painfully generic, which is that I am genuinely fascinated to see how AI is going to disrupt our industry. I definitely don't think it's going to put us out of jobs, but I would be truly fascinated to have a 5-year reunion of the three of us on this podcast in 2030 and reflect on what's changed since we're talking from the point of today. I don't want to bore our listeners by navel gazing about everything that they'll probably already be thinking about, but there's obviously a few excellent products on the market already. They're only going to get better. Obviously, AI is capable of hallucinations, and it's going to throw up research, and it's going to throw up analysis that might not be right. But I do wonder whether law firms might have to take steps in relation to, especially junior lawyers and paralegals, to maybe restrict the amount of AI that they use in their day-to-day job, or put protocols in place for how they use it. Because, and maybe I'm showing my age, but there's nothing quite like doing a chronology from scratch. There's nothing quite like having to read through every page of that exhibit to work out what it says and whether the documents truly say what the other side says they say. So yeah, I'll be very interested to see how AI does disrupt our industry, because it definitely will. It's just unclear how, and it's unclear whether it will be 100% embraced by all law firms, or whether people will embrace it to a point but still maybe put in some internal bylaws in their firms to make sure that people are still developing at a grassroots level.
I think that makes total sense. I mean, I think that AI or e-discovery, the evolution of e-discovery tools or whatever the case may be, makes the commodity work that the big firms traditionally do, where you could throw bodies and bodies. It makes it truly a commodity, and it also puts a premium on the work that we all do, right? We think not just about a chronology or how to conceive a case, but truly strategy, how to finance it, how to pull various levers within one's own jurisdiction or internationally. I think it's an opportunity for all of us, right? It puts a premium on the work that we do. I'm also excited, as you guys both know, we've spent a lot of the past few years trying to figure out how to work collaboratively with other jurisdictions. The US is ground zero for some of these creative entrepreneurial concepts where we can take risk and we can get involved on plaintiff matters. But personally, sitting here, I look at what's going on in the Cayman or the UK or really all over the world to be inspiring, right? Because it creates counterparts for us to try some new strategies, work outside our jurisdiction, and really align risk, not just with our clients, but with other law firms that we collaborate. So I personally find that to be exciting. Well, thank you both for joining. This was awesome. Viewers, thank you for checking in on this episode concerning international asset enforcement strategies, and speak to you soon. Thank you.
Thank you.
Thank you. Bye now.